So I'm looking forward to talking to you today about the importance of having a will, and I will also be sharing my experience of actually losing a loved one without a will. So I'll be talking about, I lost my partner back in 2022, and it would also be great as well if you have your own experiences, if you feel comfortable to share them, good or bad, because we all have very different family circumstances and also family dynamics. So really great to hear your experiences as well and just share as as part of the Women's Wealth community. So, going to kick off the presentation, a bit of a tough question for you, and I want you to just think about this question. So, if the worst was to happen, who would you want to inherit your possessions, so your estate? So, who would you want to inherit, the money in your bank accounts? Who would you want to inherit your home? And most importantly, I think, who would you want to take care of your children who are under the age of 18? Who would you trust to take care of those, those precious children that we have? Um, my immediate thought for myself would be that I'm a mum of one. I also have a partner, a new partner, because obviously I'll be talking about my late partner, but I would want my son to inherit probably the majority of my assets. He's quite a young man right now, but that may change over time. So we're going to talk about the importance of changing your will as well as time moves on and your circumstances change. But do have a think, and if you feel comfortable, do put that in the chat for me. So think about things such as your home, your money, so the assets that you have in your bank account, and then also who would you want to take care of your children? I can see a comment in the chat. I'm just gonna see. So Jessica, you've got a question about amending wills and what happens if someone passes where they are in the process of changing their will. Does the old will still stand? I will come to that question shortly, Jessica. Hopefully throughout the presentation you'll get the answer, but I'll come back to that question for you. So have a think about it and do let me know. Will it be your children? Will it be nieces, nephews, grandchildren, charity, pet charities? Do let me know. There are some statistics, and shockingly, over 60% of adults in the UK do not have a will. And without a will, the law, not you, decides who inherits your estate. If you are a cohabiting couple, an unmarried partner in an unmarried partnership, unfortunately, unmarried couples receive nothing under the rules of intestacy, regardless of how long you have been together. So if you've been together for 5 years, 10 years, 20 years, 30 years, 40 years, it literally there's no provision. I was going to say literally doesn't matter, but what I mean legally, there is no provision for you in the intestacy rules. And also, again, back to children, if both parents pass away without a will, the court will decide who raises your children. So it's really important to think about, children when it comes to constructing your will as well. And then just in general, any disputes over your estate without a will can be very, very tough on families. You're going through a grieving process, which is, a tough time anyway. And then to have to decide what happens to your estate and make plans around that when there's no guidance can be very, very difficult. And it can take a lot of time to resolve through the courts as well. So something to think about there. So let's talk about what happens if you die without a will. So what is intestacy? So when you die without a will, you die intestate. I can't say the word correctly, but that's how you die. And the intestacy rules in England and Wales set out a really strict hierarchy of who inherits your assets that make up your estate. And the first person to inherit would be a spouse. And a spouse is a husband or wife. A spouse is not just a partner, it's a husband or wife or civil partner. So it's really important to understand that. And they inherit the first £322,000, and it's known as the statutory legacy, plus half of the remainder of your estate. And then also your children will share the other half equally. So let's imagine there's an estate that has £400,000 worth of assets, of money. That first £322,000 will go to the spouse or civil partner, and then the £78,000 remaining will be split equally between the spouse or civil partner and also the children. So that's what happens when there are children and a spouse who can inherit. If there's no spouse or no children, it then goes to parents, then it may go to siblings, Then it may go to nieces and nephews, and then more distant relatives. And if there are no living relatives that can be found, your entire estate goes to the crown. So if you're a royalist, you might not mind. If you are not a royalist, it might be a bit of an issue. And there are lots of lists where there are that you can go online and search where there are unclaimed estates. So, you need to decide what happens to your estate. Also important to talk about what a will can do and what a will cannot do. So I know that there are lots of sort of questions about what happens here. So what a will can do, it can help you to outline who inherits your money, your property, and also your possessions. It can allow you to appoint guardians for children under 18. It also can help you to choose your executors, and executors have a really important job. They are the people who carry out your wishes as set out in your will. So they are the ones responsible for doing all of that. And I'll go into what their responsibilities are shortly. It also allows you to leave gifts to friends, charities, or organizations. It also allows you to specify funeral wishes. Do you want a burial? Do you want a cremation? Any other specific requests as well. You can also set up trusts for minor children or vulnerable beneficiaries as well. So, you may be in a situation where you are caring for a loved one and you may need to set up some special provisions for them. And it overall reduces the risk of family conflict by making your intentions clear. But what a will cannot do, let's talk about that as well. It's really important. So it doesn't override your pensions nominations. So your pension at this moment in time is not part of your estate currently, but there will be changes come in on the 6th of April 2027. So with your pensions, it's really important to update your beneficiary nominations separately. So keep those up to date as well. It doesn't override joint ownership. So jointly owned assets such as property and bank accounts will pass automatically to the survivor. So if you've bought a property with an ex-husband, a best friend or something like that, and you both own that property jointly, if something was to happen to you, 100% of that property goes towards that survivor. It also doesn't override life insurance policy nominations as well. So again, it's important to keep your life insurance policy nominations up to date. And it doesn't prevent a spouse or dependent making a legal claim under the Inheritance Act. So wills do get contested. I saw a recent case of a woman who was married for 66 years and her husband decided not to leave any provisions for her in his will. The provisions went to his son. He didn't leave any provisions for her or her daughters. And basically she took her husband to court and contested the will because it was deemed that it was unfair for her not to get anything within a will. So wills can be contested, but you have to have really good grounds to be able to contest. And again, those grounds and the tests for that is set out in the Inheritance Act. So really important just to understand, yes, you're creating the will, but wills can be contested and it does happen. And then also a will cannot guarantee your wishes if the will is made and it's invalid. So there are some reasons that a will be invalid, and I'll talk about that shortly. So we need to make sure that we are creating our wills and making them correct so that they aren't invalid. So we'll talk about that as well. Have you also thought about, how many of you have a social media account that you post on, whether that is for personal reasons or it could be for business reasons? You need to think about what will happen to your digital life. So, within a will, you can put instructions about what happens to your social media accounts. Should they be memorialized or do you want them just deleted? Any email accounts that you have. A lot of us work whereby we upload a lot of things to the cloud. Your cloud storage, what happens there? Also things like, cryptocurrency wallets, passwords, and I'm not saying to put passwords in your will, don't do that. But you need to think about, giving people access to, who you want to have access to this information when you're passed. Also, cryptocurrency wallet, I've already said that. Also, online businesses that you may have, any intellectual property. I'm an author of a book, so I did Google and to see what happens, to kind of any royalties that I may get. For my book. So, intellectual property, the things that you own, you need to think about what happens to that. And you can set that out in a will. And again, don't put passwords in your will. Please don't do that. Okay, so when you are thinking about how to set up a will, you need to make some key decisions before you write it, before you put pen to paper, or before you sit down to speak to a solicitor. So you need to think through several important decisions. Number one, who are your beneficiaries? And your beneficiaries are the people or organizations who will inherit from you. So you might want to consider your spouse, so husband or wife, civil partner, or a partner, so a cohabiting partner that you have, your children, and what age would you want them to receive any inheritance. So that's really important. You need to think about the level of maturity. Do you want them to get everything at 18 where they might spend it all, or do you want them to be a bit older? Do you want them to get the inheritance to be able to do things such as go to university, set up a business, get on the property ladder? Really important to consider, your children's age and when you want them to inherit. Also, if you've got any stepchildren that you've raised and you care about them, they're really important to you, they do not automatically inherit under the intestacy rules as well. So you have to specify stepchildren. So do remember that as well. Grandchildren, you might want to make beneficiaries of your siblings, your parents, close friends, charities. On the point of charities, a gift to a charity is also exempt when it comes to inheritance tax. So something to be aware of. And also, there is a possibility that the beneficiary who you put in your will may pass before you. So are there any other substitute beneficiaries that you might want to put in your will called contingent beneficiaries? The next thing is thinking about who your executor is. So your executor is responsible for registering the death and obtaining probate, collecting all your assets. So contacting, the banks, building societies, letting them know what's happened, getting all of that, insurance companies, pensions, all of that, contacting all of these organizations and collecting all of your assets in. They are responsible for paying any debts as well. I think sometimes there can be a misconception that when we pass away, all of our debts are just written off, but that's not the case. If you have debts, you do have to pay them unless your estate has, unless there's nothing in your estate, and also any taxes that are due. So I've mentioned inheritance tax, so inheritance tax that is due on your estate. It might be taxes because your partner was self-employed and they haven't paid their self-assessment. Any taxes that are due need to be paid from the estate before distributing the estate to the beneficiaries as well. And it is a significant responsibility. A good executor should be trustworthy and organized. Ideally, they will be younger than you, or at least likely to survive you, survive you. They have to be willing as well. So always ask for the executor before naming them if you can. You can appoint four, especially if you go through probate and go through that process, you can appoint four, but naming two is a common practice. And you can also appoint a solicitor as an executor, although this comes at a cost. And it's also important to note that an executor, even if they're named in the will, doesn't have to take on the responsibility. So they do have the right to kind of change their mind. So you might put someone as an executor in the will. They may find out when you pass if you haven't told them. But they don't have to do that. And someone close to the person who's deceased may take over that role. Another thing that I mentioned is guardianship for children. So if you have children under 18, appointing a guardian is arguably the most important decision you'll make for your will. Think about who shares your values, your parenting style. Are they willing to take on the responsibility? Do they have capacity financially, physically, emotionally? Have you spoken to them? Ask them first, have a conversation. If you and your partner both pass away and no guardian is named, a court will decide, and they may choose someone that you wouldn't have chosen. So, if you can name a guardian for your under 18s, that would be great. Also, within the will, you can specify gifts and sentimental and items that are of sentimental value. So think carefully about specific items that you have a particular sentimental value. So jewelry, artwork, a car, any collections that you have, and these can be left to specific people. And this often prevents disputes more than anything else. And it might sound morbid to have these conversations with your family members about who gets what, but it can also avoid, difficult conversations. So, my mum's got a mirror that she's had since I was a child, and I think it's going to go to one of the grandkids rather than one of her children. But we've had kind of conversations about that, and it's, probably not very valuable, but it is an item that, I've grown up seeing, my son and my nieces and nephews have grown up seeing, and someone's got their eye in it already, and they're having a conversation about it. Um, I wanted to just touch briefly upon inheritance tax. It's quite complex, so we won't go into it in a lot of detail, but it's good to have a basic awareness, basically. So your inheritance tax is currently charged at, or inheritance tax is currently charged at 40% on estates above 325,000, which is the nil rate band. And there's an additional residential nil rate band of 175,000, which may apply if you leave your home to your children. Gifts to a spouse are always tax free, and also gifts to UK charities are tax free. So you can do some careful planning through your wills using gifts that can help to reduce your inheritance tax bill for your families. So, but if your estate is quite complex, loads of money, quite valuable in there, it might be worth speaking to a solicitor or someone more specialist about IHT planning specifically. But it is something to think about. Importantly, how you can create your will. And there are a number of different options for doing it. So you've got from free up to sort of £100, simple DIY online wills. There are some organizations that allow you to do that. I think one of the first wills I created for myself was through the Fair Wills online platform. So you've got Fair Will, you've got Quill or which will give you a guide. It will ask you standard questions for you to create your will. And it's fine for straightforward situations. So if you are married, you've got children within that marriage relationship, and simple assets. The only risk there is that getting the wording wrong can render the will invalid, or it can create unintended consequences. And we would suggest that you never try to write a will entirely from scratch without any template or legal guidance. But there are lots of online tools that you can use to write a will, and which is quite a trusted source there as well. You might use a high street solicitor, and it costs anywhere from £150 up to £500, depending on complexity plus. And it's recommended for most people, and a qualified solicitor ensures your will is legally valid and properly worded. They'll ask the questions that you might not have thought about. It's something that if they're doing every single day, or quite frequently, they'll know what to ask. They'll know what scenarios and situations come up. And especially important if you have children from a previous relationship, if you own property abroad, have a business or a complex financial situation. The third option is a will writing service. So these are companies that are not solicitors, but they specialize in will writing. And it can be a cheaper option than solicitors, but they are not regulated in the same way. So you might want to check if they're a member of a membership body, such as the Society of Will Writers or the Institute of Professional Will Writers. And also be a bit cautious, about any aggressive upselling. So if you've got a straightforward will, you should not be required to use expensive storage schemes or even, have a trust product added if it's not something that you need. So professional will writers are a option. It's important to understand what makes a will valid. So what are the legal requirements for a valid will? So number one, for a will to be legally valid in England and Wales, it must be made by someone aged 18 or over. Okay, so 18 or over is the age where you can create a will. It must be made voluntarily without any pressure from anyone else. It also must be made when you have something called testamentary capacity. So, i.e., you understand what you are signing. In order for a will to be valid, a person must have sufficient mental capacity to make it in the first place. It can be in writing, so it can be handwritten or it can be typed, but it must be in writing. And it must be signed in the presence of two witnesses. Okay. And so both witnesses, it must be signed by both witnesses in your presence at the same time. Another thing about witnesses is that they cannot be beneficiaries, and you cannot use a witness who is a beneficiary's spouse as well, which is a common mistake that kind of invalidates wills. Other common mistakes, and let's talk about that now while we're talking about what makes a will valid, is, again, witnesses who are beneficiaries or married to beneficiaries, signing on different occasions or not in front of both witnesses simultaneously, Attempting to amend a will by crossing things out. So any amendments must be a formal codicil, which is a document, and it also has to be witnessed as well. So you can't just cross out what you've put in your will and add notes like we can with other documents. It won't be legal, those changes. And also signing a will when you are lacking mental capacity at the time of signing, and also being pressured into signing. So that's known as undue influence. Important to review regularly your will. So I would review my will if there are major life events, i.e., getting married. And it's important to know that if you are getting married, any previous wills that you have are automatically revoked. So you need to create a new will, or within the will, you have to say if you're creating a will before you get married, you have to say in anticipation of getting married. Not those exact words, those exact wordings, but it has to show within your will that you know that you're getting married to this person. Otherwise, it will revoke any previous will. So important to think about. Also, getting divorced. Funnily enough, a divorce does not revoke the will, yeah, but it does remove gifts to ex-spouses. So a divorce will not revoke a previous will, but a marriage will revoke a previous will. So bear that in mind. Um, when you have grandchildren, as your family expands, when you have children, further grandchildren, you might want to put name them as beneficiaries in the will. If there is a death of a beneficiary or an executor, you may want to change, a new beneficiary, a new executor as well. If there's a significant change in your financial circumstances, if you're moving to another country or buying property abroad, if there's any changes in tax laws as well, so review every few years. So there's that change coming in when it comes to pensions. So really important to understand when to review and change your will, and then how to store your will. Keep it somewhere safe, somewhere fireproof as well, and accessible to your executors. It's not recommended that you keep it in a safety deposit box because your executors may not be able to access it without going through probate, which will require time and money to do that. Tell your executor where your will is stored. And then also other storage options include, solicitor storage, probate registry storage, which is, I think I did a Google search, it's around £23 in England and Wales today, I believe. If you're storing it at home, somewhere fireproof safe, and keep a note of its location with your important documents. So if you've got a file or somewhere that you keep all of your important documents there, at least create a document that says, in the case of needing access to, my will is stored here. So that is general discussion about wills, what to think about when you're creating one, what things you can put into your will. I'm just going to look at some of the questions, try and look at some of the questions before if there are any questions. Just have a, what about pets? Assume also good to include wishes provisions for them. Okay, let's just go through and answer some questions, and then I will share my story. Or should I share my story first? Let me share my story first, and then I'll go through your questions, if that's okay. Okay, so I wanted to do this presentation because I've experienced losing a partner without a will. So a bit of background: my partner and I have been together for 10 years, engaged to be married. We lived together in his house, and it was a house that he owned jointly with his ex-wife. We're not first loves, second loves. He had a child, I had a child, had a child. We both have sort of adult children, or my son was a teenager when we met. And like I mentioned, we planned to get married. I will say his family dynamic was quite complicated, and I know this because before he passed away, he actually lost his dad. So his dad had passed away a few weeks before. And it was a family dynamic where no one was talking to anybody. So, lots of, people not talking to each other, which, is fine. And that kind of continued when he suddenly passed away unexpectedly. We were 6 months away from our wedding date. So, it was a wedding that was booked, venue, clothing, all of it was all booked. And he passed away unexpectedly. And the rules of intestacy kicked in then. So he didn't have a wife or civil partner. So in terms of managing his estate and who would be responsible, it would be his child, his daughter. So that kicked in. So despite us being together, you know, very clearly planning this wedding, due to be married, I had no say in kind of managing his estate. And I've gotten here, you know, what happened to the house. So, like I mentioned earlier, if you jointly own assets with somebody else, that automatically goes across to somebody else. So suddenly I was living in his house, or what was his house when he was alive, but suddenly it was transferred to somebody else. So an ex-wife I hadn't known or met, who I now had to kind of deal with about his house. So it didn't belong to him anymore. It didn't belong to his estate anymore. It was somebody else's kind of problem and you know issue and whatnot. So that was pretty awkward. And then in terms of his possessions, so I'm in this house where we've built things up together, bought things together, and there was no will. So deciding, okay, what to do with the possessions, what do I keep for myself? You know, I'm going to need in the future. What does his, you know, daughter get? Really, really complicated. And there was no will, which may have set out, okay, she gets the car, she gets this cabinet, this family heirloom, or whatever. So nothing there when it came to the possessions as well. So, you know, we had to kind of muddle through that. And the biggest thing in terms of my partner's funeral. So typically, the person who's the executor of a will plan and sort out a funeral. It doesn't mean that they can't get help from somebody else, but obviously they have to want to have help from somebody else. And in the case of my partner passing away, it was quite complicated. His death was um, investigated by the coroner. So it wasn't the standard where, you know, body's released to funeral directors, they can then, you can plan the funeral. It was a lot more complicated. So I found myself in a situation whereby he passed away. I was dealing with the coroner one day, and then I contacted the coroner a few days later, and I was told, we can't tell you anything um, because we've been instructed not to tell you anything. So I had to prove to the coroner that I was a person of interest in my partner's passing, that you know, I could be kept up to date legally. So the coroner kept me up to date. It took about 6 weeks before his body was released for funeral directors. But again, I had no say in the funeral directors. Um, and then the funeral directors were instructed not to tell anybody anything about his funeral. So my partner was effectively buried in secret. It was only after he was buried that we were able to call the funeral directors and say, hey, I'm a family member. I want to put some flowers on his grave. We were given details of where he was buried. So I do know where my partner was buried, but for maybe a day or so, I didn't know, which was very difficult. Um, and again, you know, if you had a will in place, if I was the executor of the will, you know, I wouldn't have been able to be sidelined. Also, like I mentioned, we were due to be married. If we had been married as well, that wouldn't have happened. So I say all of this to say it's very important to have a will in place. You know, we can have conversations. I could tell you what I think his wishes would have been. Do I think he would have wanted, you know, to be buried and no one know? Absolutely not. But that's just my opinion at this stage. Legally, there was nothing I could do, so I had to kind of accept that. So will's very important in distributing your assets, very important in naming your beneficiaries, very important in just deciding, you know, what happens at your funeral. So I want to kind of just encourage you all to do these 5 things in closing. Decide about the complexities of your financial circumstances. You know, do you have a simple estate? Do you have a more complex estate? If you've got a simple estate, it might be possible for you to create a simple will using some of the tools that I've mentioned, or you might need to speak to a solicitor and get everything really covered and written down in writing. Think about your beneficiaries, your executors, your guardians for your children, and have conversations with them so that they know what your wishes are. Um, in terms of like things like pensions and insurances, you may need to do your nomination separate, and it's important to do that as well. You want to make sure that they go to who you want them to go to, and that your loved ones don't have to speak to the you know, the teams that handle that at these insurance companies and pension companies, and the pension companies don't have to figure it out themselves and make a decision. I want to encourage you to create a will in the next 30 days if you can. So, you know, speak to a will writer, do it online, speak to a solicitor if you can. And then also tell your executors where your will is stored. You know, the best time to make a will was years ago, but the second best time to do it is today. Creating a will is one of the most loving things you can do for the people you care about. It costs relatively little, takes a few hours of your time, and it spares your family enormous stress, expenses, and potential conflict, at what will already be a very, very difficult time. So I'm going to look through the questions. I think we are just bang on or slightly under. So first question from Jessica. Actually, can I open the floor to anyone? Does anyone want to come off mute and say anything, share a comment before I go through the questions?
Also, can I just say, Selena, you've got a lot of questions there. If
Oh
you
no.
want to, we can address these in a mail out after when we send the replay out to everyone.
Okay,
You
yeah,
can
we
perhaps
can.
answer them then if you don't manage to get through them all.
Yeah, that's fine. We can do that as a backup. Um, but any quick comments, questions, anyone before I just go through the few that I've got? No, it's absolutely fine. So there was a question. So Jessica had a question about amending wills and what happens if someone passes while they're in the process of changing their will. I would say that the old will stand. So if you haven't made a new will and it's not valid, the old will be the one that stands. And I've seen this question quite a few times because I'm part of a community who have lost, partners basically. And if you were making a will but it's not valid, then the old will stand. Um, Unfortunately. Melinda, you said I definitely leave everything to my kids, but my husband overlooking the accounts, but with my husband overlooking the accounts. So we have a complicated family architecture. So yeah, definitely create a will for yourself if there's a little bit more complexity. Donna Sebi said, my nephews, as I have no children. Is it a good idea to have more than one executor? So typically you have two, but you can have one. There's no reason why you can't have one, but um, you know, the standard seems to be two. If you have more than that, it can get more complicated, but I guess it depends on who your executors are. Do they get on, do they know your wishes as well? And May said, I've separated from my husband, but not divorced yet. Can I exclude him from my will? So if you aren't divorced, like I mentioned, even with a divorce, it doesn't revoke your will. So you would have to go through, any kind of insurance or pension plans that you have. If he's named as a nominee, update those. Also, you have to go through the divorce process. Actually, you might not want to do that just yet actually do it, but you might have to think also, if you're going through the financials of your divorce, that may mean, pensions are divided and all of that. So there might be some complexities there. But I would say, if you are going through a divorce, do create your will, do your nominees as well on these things whilst you go through it. Are you able to share the presentation slide? So there is an accompanying document that will come with this presentation. If you signed up, you should have got that. What about pets? Assume also good to include wishes provisions for them. Yes, yep. Again, include your wishes there as well. Something also to consider in this day and age, as everyone online is the contents of your phone, computer. Yeah, absolutely. So putting those provisions in your will is also important. Letting someone know where they can access kind of passwords, not putting your passwords in the will, but letting them know where they can access that. Susan, you said I did my first will through Free Wills, through Free Wills Month, which is great. Yep, absolutely Free Wills Month. There are lots of times throughout the year where we are encouraged to create wills, and there could be benefits of doing that. Are wills lodged centrally or just with solicitors? Just thinking if solicitors close down, what happens? So you can lodge your will um, with, I can't remember the name of the office, but there's a specific government office where you do lodge your will. Um, and if you're worried about, maybe a solicitor closing down, um, it might be best to do that. But also that there are processes in place. If a solicitor's office closes down, it may be a pain, but there should be processes in place whereby your will still exists. Um, um, so May said, when my father died, his solicitor asked my mum to sign over control to him, even though my sister was listed as the executor. Oh my God. May, it's a really good question. I don't know if that was legal or not. I'm not kind of an expert in this area. Um, But I mean, if you have questions and queries, I would seek legal advice. I mean, if your sister was the executor based on a will that your father had, then if there was some change there, I would seek legal advice about that. Uh, we are kind of running out of time. Yes, I do need to talk about our next kind of Finance on Friday session. So any final questions and comments that I haven't got to, we will come back to you with a bit of a handout post email. I just want to say, thank you all for joining myself today. I hope you found the session useful. You can join Women's Wealth free by signing up to our Enable membership today and gaining access to carefully created, curated content. We have courses on how to start investing, resources to help you manage your money and create a fabulous financial future for yourself. We are authorized and regulated independent financial planners. And for those who need a more one-to-one service, you can upgrade your membership to suit. If you would like to explore how working with us would benefit you and improve your financial well-being, you can book a time to talk to one of our money mentors through our website. And some important dates for your diary on the Friday, the 27th of March at 12 p.m. So again, it's another Finance on Friday session. We'll be talking about the end of tax year, so how to use your allowances to the max. So that's super, super important. And our next live session is our Ask the Advisor session, which is happening on the 12th of March at 7 p.m. And you can feel free to email questions beforehand. And the email address is www@womens.wealth, womens-wealth.co.uk. So you can send through your questions in advance, or you can show up and ask questions on the day. Thank you so much, everyone, for taking part in this session. I do hope you found it useful, and I hope to see you at our next session. And we'll get those questions answered. Any ones that we've missed, we'll try and get them answered for you. Thank you, everyone.